Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello and welcome to the program. My name is Justice Maduforo. I'm a solicitor of the Senior Court of England and Wales. I'm also a barrister and solicitor of the Supreme Court of Nigeria. I am the director of Tice Madox Solicitors. This program brings the very best, which all of you are eagerly waiting for me to roll out each topic per day. Today is not an exception, a very interesting topic. Remember that all I say on this program, or my discussants on this program, they are not legal advice, but they are to constitute an anxious moment in your consciousness for you to take action. Simply put, raise a consciousness, point you to the eyes of the law, and signpost you to the right place where you can now have detailed taken instructions and advice, then you could then run with it. Because law is not like any other subject, because it is time sensitive, it is also peculiar to the individual, because your circumstance is not the same with the other. So I cannot, and no one should give a blanket advice or a blanket comment that has nothing to do with your circumstance, or similar but not the same. It must fit your circumstance. And that is what Tice Madox Solicitors stands for. To have a tailor-made instruction from you and give that tailor-made advice to you that suits your circumstance, and also for the purpose is to achieve your success. I will be discussing employment law today. And my topic is time limits. Employment law time limits. Employment law time limits. Why did I choose to talk about time limits in employment law? Now, I have discussed so many areas in employment law. Employment law is very crucial, especially this COVID-19 era. The COVID-19 era has thrown up a lot of things in employment sectors. Because, number one, the COVID has hit unemployment a lot. Most people who have their jobs are losing their jobs. Those who have no jobs are finding it difficult to get jobs. And those who already have jobs the employers are taking time to either ease them out of the job, either one legitimate reason or another, or illegitimate reason. It depends on the employer, it depends on the employee. Now, this COVID era portends quite a lot of actions taking place in the workplace. It stirs up consciousness in employment sectors. And as a result of that, you want to keep your job. Your employer wants to keep their business. And at the same time, both parties must win. Both parties must win. It is not a win-lose situation, but must be a win-win for both parties, because both parties benefit from each other adequately correct. But the issue is where there is an injustice or proposed injustice or potential injustice against the employee or about to take place. Then what happens? Then the employer or the employee will have to seek legal advice as to deal with the moment. The moment in the sense of the decision the employer is taking, or the decision the employee is about to take, or the decision from the employer to the employee. Now, it is spanning through quite a lot in my practice in employment law, and a lot of things have gone under between the workplace, and more especially between employer and employee. And why am I saying this? And why did I choose the topic today, time limits? Because I started to introduce to you the situation in the workplace. And then, by the way, the workplace are regulated. So because it's regulated, each party must play within the rules. Each party must play within the rules. If each party did not play within the rules, they must have a reasonable excuse And that reasonable excuse must be legitimate. That reasonable excuse must be plausible. That legitimate excuse must be believable. Now, in the workplace where situations have thrown up whereby the employee is taking action against the employer. Now, this is where the time limit comes in. It could apply both ways. Either the employee who has lodged a claim in the employment tribunal, or the employer, assuming the employee succeeded in employment tribunal, the employer decides to appeal against the decision of the employment tribunal to the employment appeal tribunal, or vice versa. The employer succeeds in the claim instituted or brought by the employee. The employee then appeals to the employment appeal tribunal. These things are controlled with time sensitive. But for the purpose of my discussion today, I'm limiting time limit to the time of which the employee was dismissed or the alleged infraction to his right, be it by claim of discrimination, breach of claim, breach of contract, a breach of so many breaches that have occurred, unfair dismissal may occur. As long as the employee has raised and felt that the infraction has been committed against him or her in the workplace by the employer about to raise the claim, the time the incident took place or the last incident took place of which the constitutes claim, within that period and to the period the employee now lodges the claim in the employment tribunal. These periods are very, very sensitive. And in my practice, most of the clients that have come who have instituted this claim by themselves in the employment tribunal, because we see more of it where the employee decide to just lodge the claim themselves, more especially when the theft or when they feel they understand their claim, especially from the investigative process in the employment, all the way to the disciplinary procedure, all the way to a decision being made by the employer, probably terminating the employment, either in lieu or without lieu of notice. And then the employee decides to take the employer to the tribunal, more especially by first taking the next step, which is appealing the decision of the employer appealing within. That appeal within shows that the employee continues to expect a decision to finally either in his favor in the appeal or not in his favor during the appeal. Now, when the employee has exhausted the appeal options within the organizations after the decision to terminate or decision to not to uphold their claim, their grievance. Now, the grievance also becomes another mode where the employee will take their claim to the employment tribunal. Not necessarily disciplinary, not necessarily that anything has occurred. As long as the employee feels that infraction has occurred or is occurring or about to occur, and the occurrence is imminent, the employee decides to take a decision. And that decision is to notify the employer by raising grievance. Now, let me talk about grievance for a while. Remember, this topic is time limit. Time limit in employment, which means the time within the claim occurred, the alleged claim occurred, and the time within which the employee or the claimant, this using the legal palace, the claimant lodges their claim in the employment tribunal. This period is crucial. The period of the claim, alleged claim, and the period the claim is lodged. It's very important. Now, the law provides that you must lodge your claim within 3 months. That is the law. And if you go beyond that, you will have to seek the extension of time within which to lodge that claim. Or you've already lodged the claim, you're seeking extension of time for the 3 months to be extended for you. Okay? Now, there are so many ways extension can occur. But before then, let me go back to the grievance I was discussing with you about. Now, grievance, most of you raise grievance to your employers. And in the process of the grievance, now, the employers have a nonchalant attitude at times in dealing with grievance. What do you do once the employer decides to sweep your grievance under the carpet? What do you do? Now, you see, the beauty of the law is that once you have those who have the knowledge and the technical know-how with eagle eye to know how to guide you, that is where you need to pause and think, who will guide me here? You have raised so many emails to your line managers, supervisors, managers, seeking that your grievance which you raised should be dealt with. But they have ignored it, or they will respond to you, but not dealing with it formally. Or they may decide to deal with it informally without dealing with it formally. So along the line, some of you have allowed it to sweep under the carpet when it was dealt with informally. But you still believe that your grievance is still ongoing. It's a lot that's going on, especially if you work with multinational companies that have to go through checks and also a lot of windows to deal with before they can deal with your grievance properly well. Now, if you're in that category, what do? Employment is crucial for you. Employment is your economy. Employment is your lifeline. Employment is your blood. Employment is your joy. Employment is your happiness. Employment is your satisfaction. Without employment, if you are in employment and you're having issues in your employment, or you've been terminated from your employment, or you're going through issues in your employment, that leads to depression, that leads to complete frustration. So therefore, in order to take hold of it, you need to go arm in arm with Tice Madox Solicitors from the first moment. That is where we are so empathic. Empathic in the sense that we'll take your case, understand what you're going through, and make you relaxed and deal with it step by step with you along the way. That is what we do at Tice Madox Solicitors. We are unique. We are leading in the market. And because we're leading in the market in these areas of law, we understand the times. We understand the rules. We understand how to play the game on your behalf to achieve your success. Success is the end product of what we do for you when we take on your case. Ladies and gentlemen, I'm dealing with grievance. Remember, you raised grievance. Some of you are sitting on your grievance as you hear me speak today. Your grievance has been dealt with. Either you are satisfied with the outcome or you are not satisfied with the outcome. The issue now is that once grievance has been dealt with and you are satisfied with the outcome, the question now is that, does that preclude you from taking your case to the employment tribunal or raising a claim? Now, it's a complex area, but depending on your response to the decision regarding your grievance. Some grievances are as a result of bullying, as a result of harassment, as a result of consistent, constructive, adverse actions against you by your employer, by consistently making your work very, very unfavorable for you, frustrating you in your job. Some of you are pressed on with a whole lot of workload that you could negotiate that out, but you couldn't negotiate that out. You carry on. Now, the question now is that when grievance has been dealt with and you feel that it is time for me now to lodge a claim in the employment tribunal, perhaps you've accepted the outcome of the grievance and then you felt that the whole incident is still ongoing. The issue that was dealt with in the grievance is still ongoing despite the fact you've accepted the outcome formally or sometimes informally. When does the time limit start to click? I say this because you have 3 months. 3 months. And the tribunal is so unflexible when it comes to you missing your 3 months time. I said this so that you could understand that 3 months is important. The tribunal is very conservative when it comes to applying 3 months. Even if the tribunal didn't raise that, the employer, the respondent in this circumstance, will raise it and will be a preliminary issue to be dealt with. When preliminary issues of out of time are dealt with, you need to come up with a very stronger excuse and reasonable excuse why you did not lodge within time. Now, I'm going to talk to you about the next step there, which is calculating the time limit. Calculating time limit is another thing, which is why you need solicitors who can deal with matter, understand how to start from calculating time limits. Time limit discussion is a very wide topic because it's multifaceted, because it had to deal with so many areas and so many circumstances that come up to determine when time begins to click. Ladies and gentlemen, Listen, I've dealt with matters of this nature, and I know clearly, and I can tell you that time limits are not matters that you go argue yourself. If you're out of time, you need to run back to Tice Madox Solicitors. Run to Tice Madox Solicitors. The telephone numbers are on there. Our contacts are on there. You could just watch us on YouTube. Our details are on YouTube. Our details are on Facebook. Details are on Instagram. Details on Twitter. So you couldn't say, I can't find your details. On the website, ticemadox.com. There you contact us immediately so that we can take detailed instruction from you and then begin to know how to apply the time constructively, technically, or on the surface common law. Ladies and gentlemen, time limits are important. There's a lot of decisions made, especially during this COVID-19. The court has been filled up with decisions dealing with out-of-time applications. Out-of-time applications are so many because a lot of people think because of the coronavirus issues, this is a good example. It's not a good example to some extent. It is not. But you got to marry it together with other host of circumstances. That's why you come to those who understand what circumstances are plausible, what circumstances are believable, what circumstances are applicable, what circumstances are required, what circumstances constitute the ingredient to extend time when you are out of time. Ladies and gentlemen, I can tell you this because when there are circumstances where you need to understand how you need to flow with the issues, you will be able to know clearly whether you are on the right path in your grievance or your claim, or you are not. Ladies and gentlemen, from the grievance, the phone just rang to let you know how busy we are. But question is that, when does time begin to click? When is it said that you're out of time? When is it said that you have missed the time limit? Some of you begin to calculate it by your own reasons, by saying, okay, decision was made yesterday, and therefore I start to lodge my claim. That is not it. Now, when we prepare matters in the employment tribunal, there's what is called Scott schedules. That's what is called schedules of incidents, and of which that the timelines are drawn. Timelines are very crucial or important, and that enables the court, the tribunal, to know and understand what argument each party is applying or running on. The timeline of when the circumstances occurred, the timeline of when the grievance was raised, the timeline of when decision was made, the timeline of when that circumstance was raised. These are the issues that we dealt with during that moment. Now, the timeline is important. These are prepared in the schedule. Not everything that you understand to deal with in the employment tribunal. Let me tell you something here. Some of you feel that let me go and do it myself. Some of you feel that you can do it yourself. Some people feel that you can run and represent yourself. Yes, you can. You can treat yourself. You don't need a doctor to treat you. Do you need that? But yes, you do. Because why? They're expert in their fields. They see what you don't see. They understand what you don't understand. They use the surgical needs and the pills and the drugs that are required and the dosages that are required. They prescribe with you accordingly. That is why you must run with the expert when it comes to your health. When it comes to law, people feel I can do it. I can run with it. Yes, there gets some extent that the court will not assist you to do that. But why would you do that? Why would you want to risk losing the claim that you have that is formidable, and then with your responses and with your preparations of documentations during these hearings, you lose your case and it becomes an evidence against you? It happens. It happens. Why do you want to do that? Now, the point of raising grievance up to the point when you feel that you need to lodge a claim. Now, pause and I'll discuss ACAS here. ACAS are a reconciliatory agency. Okay? Their decisions are not binding on the tribunal. These are reconciliatory agencies that try to reconcile within you and your employer. Most of the time, the statistics have shown that most employers are not even willing to abide or go through mediation with ACAS. But the law provides that you have to at least submit yourself to ACAS to see the possibility of mediation. And when mediation fails, therefore, you issue the certificate to show that you have come through ACAS. The tribunal will see that. Okay? Now, there are consequences if you don't go through that and lodge your claim direct. Fair enough. This is another topic entirely I will discuss with you afterwards. But you have your ACAS there. Now, time limit. When do you start to calculate time? Some people don't get the time calculation. They don't understand when the circumstances that is the main issue as occurred in terms of the allegation, discriminatory allegation, breach of contract allegation, unfair dismissal or constructive dismissal allegation. They don't understand when it actually took place. More especially, detailing more in discrimination cases, be it racial discrimination, be it age discrimination, be it marital discrimination, be it disability discrimination, anything that had to be religious discrimination, and all sort of things. Even the breach of contract, victimizations. They don't know when the incident occurred, when the circumstances said to have occurred. You don't only to understand when the time applies. Then, therefore, you could be able to apply this during the trial, during the tribunal. So the tribunal is clear as to understand when the incident occurred. You don't want a case, listen to me, ladies and gentlemen, whereby the employer or the respondent in this instance applies for a preliminary case, a preliminary hearing to deal and argue of your timeline, of your circumstances, to show that what you are asking for, it is out of place. The court tribunal does not have jurisdiction to deal with it. You don't want to argue jurisdictional matters when your claim has just started. Do you want to do that? But that's why you come to us from the beginning. We'll deal with these matters with you. Listen, I am so passionate when I talk to you about legal matters because I know your life depends on the law. Law is crucial and fundamental. Human beings live on the law. Without the law, there'll be anarchy. Without the law, your peace of mind would not be restored. And why would you not want to engage with the law through the right source, Tice Madox Solicitors, to guide you, not only in employment matters, also in criminal matters, also in family matters, also in immigration matters, in civil matters in the county court, in the high court, in the court of appeal. We can deal with that for you at a very affordable time, affordable price for you, that you are relaxed and we run it. You leave it in the hands of the expert who understands the game, understands the time, understands the trade. Ladies and gentlemen, I've been discussing time limit in employment tribunal. Time limit is very crucial. Time limit is very crucial. You do not want to start a claim in employment tribunal whereby you are dealing with preliminary issues that have to do with the jurisdiction of the court. Jurisdiction of court in respect to the time when you lodge your claim that is out of time. When you've done that, you have already begun to question your claim. You already begin to question the quantum of your claim. You already begin to question the success rate of your claim. You already begin to question the viability of your claim. You don't want to do that. There's a lot that goes behind if you fail to seek and obtain extension from the tribunal so that your claim will continue. Once the tribunal rules that you're out of time, your claim is dismissed. Why would you want to do that? You do that because you are looking hard to save money. You're looking to feel that you can do without the expert. That is penny wise, pound foolish. Penny wise, pound foolish. Now, coming to dealing with your matters in a very easy and stressless manner for you. Tice Madox Solicitors will pick up your case, your claim, during your investigative process, during the disciplinary process, during the claim, even when you're going through any other grievance procedures as well in the employment. Tice Madox Solicitors, we will guide you from the beginning. We'll make sure that it is cost effective for you. How will you do that? When your claim is not going to the employment tribunal, having prepared it from the beginning, we will be able to tell you exact quantum of your case. We will take you through the process that you will not lose anything, but rather anticipation is success. You can fund your case through damages-based agreement. We do it no win, no fin for you. No win, no fee. Yes, you heard me. We will assess your case. We will deal with the matter even through agreed fee agreement, agreed fee arrangement. We will do it also through that, through your legal services, through your legal protection in your home if you're a homeowner. That could also deal with your employment case without you spending anything. That is through your insurance from your home. Every house owner have legal service or legal cover for employment matters in your house, in your employment, in your insurance, in your property. You can also speak to them, or Tice Madox will speak to them on your behalf to make sure that is the correct. This is so many ways to fund your case. So many ways that you don't have no excuse why not to go to a solicitor, why not to come to Tice Madox Solicitors. Ladies and gentlemen, it's been a pleasure discussing this. I wish I had all the time to go on to expand more into time limit, but I bring this consciousness to you. Time limit is important. If you're in employment right now, you may be dwelling on it. You may be going through procedures. You may not even have started. Pause there. Think. Call Tice Madox Solicitors, who will guide you through to tell you and raise things which you do not even know. Things you do not even realize are very crucial and fundamental. No matter how you discuss with your family and friends, it can never be substituted with the advice of the experts. The expert remains the expert, and that is Tice Madox Solicitors. Ladies and gentlemen, it is your favorite Justice Maduforo, your favorite solicitor. This favorite firm, Tice Madox Solicitors, will all handle your matters in a way that you will be comfortable and relaxed. Contact us in all the social handles you see. Telephone numbers are on there. You come to the office. We'll sit down and discuss with you. We can do your consultation through Zoom. We can do that through TeamsView. We can do that through all other means, through telephone. We can also conduct consultation through videos on WhatsApp, FaceTime with you. Wherever you are, you don't even need to come to the office. And any document we send to us by email or fax or post, that we can consider that and prepare your case accordingly. Until then, ladies and gentlemen, keep watching this program and subscribe to our YouTube channel, Tice Madox Solicitors. I remain Justice Maduforo. Till next time, God bless you.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional,